retired from there in June after about 33 years. And that gives me the freedom to express more opinions than I would have otherwise been able to do. Hi, Jeff. I really appreciate your asking me to talk today on this subject. I can't think of any, well, actually I can, but few topics are more important, or certainly more important to women and women's history. Biologists tell us, and by the way, I'm not going to be talking for 45 minutes. I think this will take 10 to 15, and then we can have a good discussion, I hope. Biologists tell us that propagating one's own genes is the strongest human instinct. And many people, and I might well be one of them, would say that their children are their greatest joy. But consider this on the other hand. Without contraception, the average woman would bear 12 to 15 children during her lifespan, and likely spend her life trying to ensure the survival of those children. Thus, all the other rights of women to educate themselves, to work, to achieve outside the family, and contribute to a larger society could be said to depend on the right to and the ability to limit reproduction. Now, people see this issue very differently, of course, and that's been when I learned, or when I decided at the Dean's kind invitation to teach this seminar. The colleague and I, the colleague with whom I'm teaching it and I, had long thoughts and then long discussions about how to handle the fact that we too, and everyone else in the world who's sentient, I think, has an opinion, and often a pretty strong opinion, about abortion access, contraception, somewhat less so, but it's a highly divisive topic, and there's just no question about that. And how were we going to handle it in the classroom? We decided, the first decision we made was it would be counterproductive to try to hide the ball, to try to have 13 weeks of discussion with people without revealing one's own point of view. So what we decided, and afterwards you can ask Jeff Philippin how he thinks it's working, that we would offer everyone in the class, at the beginning of the class, the opportunity to state his or her views based on morality, religion, or any other basis with respect to any issue that was going to be raised in the course. And of course, students had the syllabus in front of them. Our thought was we'll give people 2 or 3 minutes, they'll be uninterrupted, and their comments will not be commented upon by anyone else. And not only did we want to just give people who wish to use that opportunity the chance to get their views out on the table, but we also thought that giving them that chance would free all of us for the remainder of the semester from having to subtly or directly go over that ground again with respect to every issue that came up. Another thing we decided, which I think went well, was neither of us felt comfortable because we are both pro-choice. My colleague has somewhat different views than I, but I think both of us, and certainly I, and she also, would be put in that. When you're dividing the world into 2 groups, she's in that group also. So we didn't feel comfortable having ourselves or several other speakers that we knew we were going to have, and not having someone very distinguished, very capable, to the extent that we could get it, and we did get it in this case, to present a pro-life point of view. So the second, I think it was the second class, we had Professor Lynn Wardle from Brigham Young Law School, a Duke alumnus, a very distinguished man and legal scholar who was kind enough to come all this way. He teaches on Monday and Wednesday, and he came to our class on Tuesday from Provo, Utah. So my view is more or less what I just expressed in the sentence before going into what we do in class, which is that all that women do, and much of what men do, depends on their ability to limit reproduction if that is what they choose to do. Your view is entirely welcome at any time while I'm speaking or after we begin a discussion. And the more contrary, perhaps the more interesting. Throughout history, and here is, by the way, I know this was announced as in the Daily Law Bulletin as a discussion on the history of reproduction. Well, I had misunderstood and thought it was current issues in reproduction. But for those of you who came to hear the history, I'm going to post on the Women's Law Students webpage my 8-page single-space lecture on the history of reproduction, which is really interesting. I learned most of it, not what I took it from 2 sources almost entirely. Almost all of this was news to me. I knew the 19th century history in the United States pretty well, but I did not know, for instance, that the first recorded instance of, the first written record of reproduction limitation is an Egyptian papyrus note in 1850 BC that is a recipe for contraception. And then all the things in between there in the 19th century in the U.S., some of which you will find alluded to, and you'll find some directions to sources in the notes that are going to be posted. Throughout history, men and women have limited population. I mentioned the earliest written record. We can also tell, population scientists can also tell from looking in various historic periods at the number of people and the available food resources. And when the number of people is considerably smaller than the amount of food available, they infer that people were successfully attempting to and did successfully limit reproduction then. In the West, there's evidence of that both during classical antiquity and up through the Middle Ages, despite growing opposition from the church during the Middle Ages. Knowledge of contraception and abortion, though, was largely lost. And this, again, is a very interesting aspect of the history. It almost winked out as a light or a whatever, other people might look at it differently, after the Renaissance, but never entirely. And throughout this long period I've talked about in the West, people were using primarily herbs, but also some surgery. Now, you would not have wanted to have surgery in, say, 1050 AD, but people did that. People did this occasionally, and some people survived. And also a few devices, some of which are actually, if you step back a little and forget the feelings of the individual people, but pretty funny. The herbs people used across the last 20 centuries were retested, many of them, let's say 9 out of the basic 12, have been tested in the last 20 years in modern laboratories, and most of them have found to be effective for exactly what they were used for, contraception and/or abortifacients. In most times and places, then, society has approved of or at least tolerated abortion and contraception. Intermittently, though, government disapproves, and some regimes are more cruel than others. For instance, in the United States from mid-19th century to 1970, with Roe v. Wade coming in 1973, but actually abortion access greatly widening between 1970 and 1973 in the United States. There was, during that long period of over 100 years, there was almost no legal abortion. States had statutes almost exactly like the one that the governor signed in South Dakota yesterday. Abortion only for the life of the mother. And if you're a physician, you're pretty nervous about proving that the life of the mother would have been lost. So it's even more restrictive than it might sound at first glance. And then for a more modern period, think of Romania under communism. For us in the United States, another period of suppression has begun. In fact, I would say it's well underway, but the pace is sort of quickening at this point. Even when when birth control and abortion are illegal, it does seem to continue. doubtless with, in all societies, with detrimental effects to the financial health and the physical health of women involved. Abortion and contraception are especially available to the well-to-do and well-connected, and in my opinion, best I can tell, they always have been and they always will be. So now that you're over 18 and students at Duke Law School, I suspect that you're going to be able to control your reproduction as you see fit, with a certain few exceptions that perhaps we'll have time to discuss. But for the most part, those who are affluent and educated have access that is denied to most people, either here in the United States or abroad. And I'd like to tell you how it is for many of them, and begin by using 3 true stories that I think show the injustice of our present abortion laws. And I'm not talking about what might happen tomorrow or 6 months from now or a year from now. I mean now. This is I've been doing a project on that involves minors, persons under 18's access to contraception and reproduction. And this is one of the saddest stories that I've heard in this 10-year project. A Latina girl under age 18 walked over the U.S. border from Latin America, and they came to, she and her brother, in a group with others, she and her brother came to a large venue in North Carolina. I won't name it, because when I interview lawyers and judges, I usually do, and I feel I have to, or else they would not talk, wouldn't say very much to me, promise them confidentiality. So this is a story that I got from the attorney who represented this young woman. Soon after they arrived in this large North Carolina county or city, the brother went off to another part of the United States where he had worked previously, leaving his sister in the care of near strangers. She had been unknown, I think unknown to him. Actually, that's a little more than I know. That was not a detail that was told to me. She had been raped on the trip by the coyote, the person guiding people across the border. And she discovered after her brother left that she was pregnant. I have no idea how she found out about, she spoke no English whatsoever. I don't know how she found out about the judicial bypass as being available in the county she was located in. But she did, and in this particular county, every minor who attempts to, who seeks a judicial bypass is referred to an attorney. That's not true everywhere. So this young woman presents herself to the attorney, tells the attorney this story through a translator, and then has her, the attorney represents her in her bypass hearing. It was a new judge, the attorney says, and that may have, we'll assume that that's why the judge was not aware that a petition must be granted if the minor is a victim of rape. What's more troubling, perhaps, or equally troubling, is that the attorney didn't know until my conversation with her that that is the case. And she has represented a great many minors in bypass petitions, and she didn't know that North Carolina statute says that one of the reasons for which a bypass petition must be granted is if the petitioner has been raped. The judge, after this brief hearing, through the translator, said she can call her parents in whatever Latin American country and get their permission. I'm not granting this. The lawyer then has the translator, after the judge leaves, tells the translator, or has the translator inform the petitioner of this. The petitioner gets up and walks out, and the lawyer has never seen her again. She said she had no opportunity to tell her that they could appeal, that she was absolutely certain that that decision would be reversed by the chief judge or another judge to whom it was assigned on appeal. That's one case. Second, The next two are actual reported cases, so, and they also got newspaper plays, so perhaps you know of them. Jane Doe and her husband, a Navy enlisted man, this happened a year or so ago, I would guess, learned that the fetus that Jane Doe was carrying was anencephalic, and they wanted an abortion. Now, even if a woman is in the military, or even if a woman in the military or a military dependent is willing to pay, I expect many of you know, no abortion can be performed in a U.S. military facility except to save a woman's life or when the pregnancy resulted from rape or incest. Until 1979, and I want to mention this to show you the ways in which Roe has been restricted. Until 1979, there was another reason when severe health consequences might result. That was dropped in 79. Until 1988, a woman could pay for her abortion herself in a military facility. That is no longer possible. Many of you will sympathize with this couple's situation. Anencephaly is a condition, it means without brain. It's a condition incompatible with life. Only 1/3 of anencephalic infants are born alive. Fewer than 2% of those survive for more than a week, and the longest life of a anencephalic infant is 2 months. Once the condition is discovered, almost every pregnant woman chooses abortion. But remember the conditions of the military law, or the law, U.S. law affecting the military. The woman's life is not usually in danger in an anencephalic pregnancy, and the abortion is going to be a late abortion. It's going to have to be done in the hospital, and it's for those two reasons going to be very expensive. The Doe's income was under $20,000 a year. The abortion cost $3,000. After obtaining it on their own, Jane Doe sued for a declaratory judgment that her right to equal protection was violated because there was no rational reason in this case for denying reimbursement for abortion. The Ninth Circuit, citing the Supreme Court precedent, Harris versus McRae, pointed out that, said that the state's interest in protecting fetal life is sufficient reason. And Doe's attorney responds and says, we're not talking about human life here. This was not a possibility in this case. But the court said that statutes do not have to be perfect. They don't have to fit every circumstance. And then interestingly, perhaps because it was the Ninth Circuit, the opinion ends with an apology from the judges for the result required by law. Third case, Jane Roe, arrested in California last August for violating parole in Missouri, and the original, the matter for which she was on parole, I forget what it was, but it wasn't terribly serious. And I want to mention to you that her crime for which she's arrested is parole violation, and the underlying crime was not terribly important, just to show you that while this can't probably happen to any of you, it can happen to a lot of American people. She asked to be taken to a hospital for an abortion right after her arrest. At that time, she was 8 weeks pregnant. Instead, she was returned to Missouri, where she immediately made the same request. But Missouri had a new policy, refusing to assist an inmate in any way to obtain abortion unless she will die without an abortion. Well, Jane Roe had actually raised the money for her abortion, but under the new policy, she was also going to be charged not just for the price of the abortion, but for the prison officials' time to transport her and for the gas and more than she had. The ACLU appealed for her, and a federal district judge ordered her taken. Missouri officials refused to do that, and then that case came before the Supreme Court, the one who's assigned to a region of the country, who in this case was Justice Scalia. He at first suspended the order, and then after a couple of days he affirmed it, which makes her the lucky exception among Missouri inmates. This woman did get an abortion, but she got a 17-week abortion instead of an 8-week abortion, and there's a big difference there. It's, of course, more dangerous for her, more expensive, and more troubling. So I suggest that you let these women stand for the thousands who cannot get what they need when they need it under our existing abortion laws. These include poor women, Native American women who must use the Indian Health Services, all federal prisoners and many state prisoners, minor women and girls, military women and military dependents, disabled women who depend on Medicare as their insurer, Peace Corps volunteers, and others. 1/2 of the pregnancies in the United States are unintended. 1/2 of those are aborted, but and that's a large number. We have a significantly higher abortion rate than most industrialized countries. It is not, however, one of the highest in the world. But anyway, so we abort, 25% of U.S. pregnancies are aborted. A study by the Duke, but even there's evidence from an interesting study at Duke, and I've seen one other to the same effect, that suggests that that is not as many as women would abort if they had the opportunity to do so. The study that the Duke School of Policy Sciences did in North Carolina several years ago concluded that 1/3 of children born to indigent women would have been aborted if the women could have afforded the procedure. They did this study after North Carolina's state abortion fund, which gave indigent women chits or whatever we would call it, to paid for abortions for indigent women, was wiped out in 1995. Contraception, I'll say a word about contraception and then I'm almost finished. Because of the fierce opposition to emergency contraception, in some ways, if you believe in abortion and in reproductive limitation or the people's right to it, it's an even sadder tale, because we now have this emergency contraception that every source I have seen on the topic says could eliminate 50% of the unwanted pregnancies in the United States and 70% of the abortions that are performed in the United States. And we're sort of pedaling backward from that opportunity as fast as government can go. Even now as a prescription drug, EC is credited with a huge decrease in unintended pregnancy and abortion. And therefore, again, this is entirely my opinion, not that of the Institute of Government, my colleague, or anyone else. The battle over making emergency contraception available to U.S. women leads to the question of whether opponents are serious about restricting abortion, reducing abortion, rather. Because here's the way to do it. And as you know, and as Jeff can tell you, I can talk about this at great length, the Food and Drug Administration has declined to make emergency contraception over the counter. Their expressed concern of the director at the time the decision was made is that it might promote promiscuity among young women, and he was not sure whether he had legal authority to say it's off limits to the youngest cohort of sexually active women, but is available, and how do you do that when it's over the counter? It's said by some anti-abortion groups that emergency contraception itself causes some abortions because it prevents, if a person is harboring a fertilized egg, it will prevent implantation. Nevertheless, that has never been the definition of U.S. medicine, nor even of the U.S. government as to what pregnancy is. Pregnancy is defined as successful implantation. So it's a novel argument, and there we have it on contraception. All right, is there any good news? Yes, there is some. Human Rights Watch last year declared abortion a core human right. It's the first time that's been done by any group of that stature. Reproductive technologies advances are aiding fertility and curbing unintended pregnancy and abortion. And finally, making abortion illegal might not mean a return to the many deaths and injuries that preceded Roe. We have, since 1973, we have better antibiotics, we have better surgical techniques, and there is, above all, a cheap drug for ulcers that is used in many, many parts of the world, all over Latin America, for abortion. It's called Cytotec. The formal name is misoprostol. And those abortions are relatively safe. And they are, you can do it by yourself in the first or second trimester. However, it is suspected of causing fetal defects if the abortion is unsuccessful. So this is not something that we want women to be doing, but it's better than what happened in the United States before Roe. I'm glad you're thinking about these issues. They affect the quality of our civic life in this country, of the U.S. economy, of international development and the way we are perceived in the rest of the world, religion, politics, and the status of women. And in addition, and finally, I would say that you are highly likely, well, I don't know about highly, because I imagine many of you will not, but you're quite likely to encounter reproductive health issues somewhere in your practice. And that could be as a matter of the state law or judicial decisions or federal law. Any comments or questions? Yes?
I have two questions. My first question is, what's the burden of proof for a woman who's seeking a judicial bypass and claiming she was raped? Does the judge have to take that on face value, or?
I suspect North Carolina's law is like, which is the only one I know intimately, though I'm thinking of studying the bypass as my next project. So let's just assume this is typical. I don't really know whether it is or not, but I think it may be. No, the statute says nothing about that. It just says, and that's true about, what the statute says is a bypass petition may be granted, and then period, so you don't know exactly how far the judge could go, but you presume that he or she could go pretty far if based on what the minor says, they think it wise to do so. But it must be granted if the minor is mature, and this is from Bellotti versus Baird, the U.S. Supreme Court case. Must be granted if the minor is mature and well informed enough to make the decision, in the opinion of the judge. And to ascertain that, a judge can use any means. Some North Carolina judges, which I think is too bad, but I understand why they're searching for some standards, trying to create some. Some North Carolina judges are requiring proof of pregnancy and proof of gestational age. Now, the reason I think that's too bad is because it imposes additional barriers on minors who already have the barriers of very late prenatal care. Many don't realize they're pregnant. Once they do think they may be, they don't know what to do. And if I were speaking to a North Carolina judge in private, I would say, why do you think those two are your concerns? It's up to a health provider who is about to perform an abortion to determine whether the woman is A, pregnant, and B, what is the gestational age of the fetus. But that's one of the grounds. If she's mature or well informed enough to make her decision. The second one is if she isn't, presumably not, but nevertheless the abortion would be in her best, or a right to make her decision, the decision herself, would be in her best interest. And third, in North Carolina, if she's a victim of rape or incest.
Okay.
That's all it says.
Do you want to ask? I'll ask it later.
I was just curious if in your studies you would run across, I mean, the 25% statistic was just interesting to me. I had not realized it was that high. And I was just wondering if, I mean, I guess that'd be really hard information to get because you would actually have to ask somebody at the time of the procedure, personal questions about why they were choosing to go forth. But have you run into any statistics? I mean, is there any way that we can tell how many abortions are performed based on personal choice, how many are performed based on rape, how many are performed based on health? I mean, do we have any information like that? Or have you run across any?
These is a single page from the Guttmacher Institute Media Kit. Guttmacher is clearly, on the one hand, clearly interested in access to reproductive means. On the other hand, and I think this is quite something for it to have pulled off, it is so highly respected that it is the source of all the figures used by both sides and everybody in the middle. So I'll put these right here, and it'll give you some of the figures I mentioned and several others. I think, do I understand you to be asking if people know why someone for what reason minors got bypasses?
No, I'm just talking about all abortions done, period. It seems like we could, as we're working to craft a good solution and figure out
why people, okay.
If we knew we had better data on,
on
how
why
many
they got
are done for health, how many are done for rape.
Yes, good, because there's a better answer to that question than the one I thought you might be asking. Yeah, I think it's probably Guttmacher, but I can look it up. And if any of you want that website, it's www.agi.agi. Well, I think it might be agi-usa.org. Anyway, just put Guttmacher Institute in Google. Yeah, I've seen something recent that was pretty extensive about reasons women give for their abortion. It said, and it ranks them, but this study didn't, and I think that's accurate. It's a little confusing. We wish it were simpler, but it didn't make them choose one. So any woman could choose, several different reasons. A lot of them were economic, and a lot of them almost sound like the same thing. In, I'm not ready to take on that responsibility. And what else was one that sounded remarkably like that?
It just seems like if you could isolate and figure things out, you could help. Where do we need more education about contraception, and then where's this things that we're never going to be able to prevent, like rape and incest and health concerns and whatnot.
Yeah, there's a lot of room for research in there and thought. A substantial majority, I can't tell you exactly what, it might be on that sheet, of women say we're actively practicing contraception in the month in which they conceived. Obviously, many of them were not doing so successfully, and there are even some polls or some questionnaires where they say that, where the reporter, the woman herself, says that. But then, those are hard. I think those might be hard things to tease out. People may not want to say exactly. And I also believe, though, that there are a lot of people in this world who think that contraception is easier and more effective than it is. You can do a lot for yourself if you don't wish to become pregnant at any period of time by using contraception and using it effectively. But let's take just condoms, perfectly used, are 90% effective. The pill, perfectly used, is a lot higher than that, about 97 or 8, something like that. But it's not perfect. And if you live as long as I do, you'll know a lot of people who are just as sharp as you are, who had more pregnancies than they wanted.
What is your opinion, considering the new laws that have been passed in South Dakota regarding abortion? What would you say is the future of abortion law in the United States? also keep in mind Alito's nomination?
Well, it's interesting to study the history a little bit and see how unnew almost everything is. That's as I said, South Dakota's law is a return to the almost universal. It took from 1850 to 1880 in the United States to get a law in just about every state that outlawed abortion except for the life of the mother. But we got there by 1880, and we stayed there until 1970. So this is not new. It's a return to a recent status quo in the United States. I keep dodging your question. What do I think is the future? Well, you know, I don't think I don't have anything special. You know, I mean, any special inside. I'm probably just repeating what I've read in half a dozen sources when I say that I don't expect this particular case to be the one that that effectuates a law such as South Dakota's, just because it's been too soon. But I do believe that, from based on what I read and heard and watching the hearings, that both Judge Roberts and Judge Alito, now justices, are not well disposed toward reproductive rights. So I would not be surprised in the next 5 years to see, I think I might be surprised to ever hear the words from the Supreme Court, Roe versus Wade is hereby overruled. People who are political strategists, which I am not, say that that would probably be a real mistake. And for that reason, people I respect consider it more likely that what we will see is just a continuation of the erosion of the rights established in Roe.
You mentioned that the United States has one of the highest abortion rates for industrialized nations. Is there any reasons why our rate might be higher given some of the roadblocks that stand in the way?
Yes. Yeah, there are some reasons, things that are definitely credited, or depending on your point of view. As compared with Europe, in Europe, and of course there's a divergence within Europe, I believe Portugal and I'm talking about Western Europe, you know, we'll put Eastern aside for a while. And in Portugal, I believe abortion is still illegal, and there's one other country. But in general, you know, in Europe, abortion is free. Sex education is extensive. I was once visiting a law professor at the University of Copenhagen who was American but had married a Danish woman and raised his family there and lived there for many years. And he was saying that as an American, he still found this wonderful but too embarrassing to bear himself. He told us that at least once a year on Danish TV, they have a primetime early evening show where a young boy and a young girl with no clothes on demonstrate how to use condoms. And he said, you know, I'm really glad my daughters are watching this, but I can't watch it. I have to go out. Anyway, it's just a really different attitude. You know, Europeans call us Puritans. We also have, for instance, as compared with Scandinavian countries, we have a much greater, we have a much more diverse population. We have much more financial differences. What's a word? Economic differences as compared with many European countries. And contraception and certainly abortion. Contraception is more difficult and abortion is more necessary as you go down socioeconomic ladders and certainly into youth. And I could give a whole lecture just about what's happened to sex education in the United States in the last 5 years. It's amazing. We had, just to name North Carolina, in 1995 we had one of the best systems in the United States, and now we have 112 of our 117 school districts teach abstinence only. Mm-hmm.
Another question concerning minors. I just read in the New York Times yesterday that the Times had done a study regarding the parental notification laws, and they hadn't really decreased the number of abortions in the states in which they were enacted. And my take on the situation was it seems okay to me, especially in the case of minors, to regulate their access to invasive medical procedures. And why, I don't know, what's the best way to make sure that, I would just assume that if a minor has to have any sort of surgery, their parents or their guardian would have to consent to it.
Yeah, that's correct.
And what would make abortion therefore special, and that we would not want that to be the case?
Well, that's the general rule. I shouldn't have said agreed to any. There are exceptions for a number of things. First one being emergency surgery. If a child is brought to a healthcare facility or a doctor happens upon a child and there's no way to, and it's necessary to treat that child immediately, then that's always an exception. Most of the states have exceptions for several different, they name several. In North Carolina it's 4, and that's fairly typical. Conditions in which minors may seek medical and obtain medical care on their own without any liability on the part of the physician. And they are treatment of pregnancy, which until 1995 included abortion, but now we have a separate statute that says you have to have parental consent to abortion. Treatment of pregnancy, treatment of substance abuse, mental illness, but that does not include commitment to a facility, and treatment of all communicable diseases. So you see a little cluster of things in which a state legislature has decided that although, yeah, everybody would like their child they would like the chance to know what's happening to their child and to secure good medical attention for him or her, but the state has decided that there are some circumstances in which that interest should be overridden by the medical needs of the child, and in the case of communicable diseases, I think of other people. By the way, only 10% of minors do not tell at least one parent. And
I would assume it would be low, that there would be, it's pretty rare that you're raised by your father. Or maybe it's less rare than I think, but.
Yeah, I think both those statements are true. And there are a lot of abusive situations involving either the parents or the male partner or whatever.
I was curious, does RU486, if it's ineffective, pose a risk of fetal deformity?
I think not.
The baby will just implant and then there won't be any difficulty. Okay.
Right. Although, but that's not what, once you take, maybe I'm wrong about that, for whatever reason, maybe it's for the health of the mother, I don't know, but once you start an abortion by pill, which is RU486, it does have to be completed.
Okay.
Mm-hmm.
Is there anything legally that would prohibit the morning after pill from being treated like other age-restricted goods? Like, in other words, like alcohol, tobacco, pornography? Is there anything that would prohibit being able to sell
with
sell it over the
identification?
counter with an ID that you were over 16? Or whatever?
Well, that was suggested when the, I don't know that there is, and it was certainly suggested by the advisory committee. This is the first time in, I think this is the second time maybe the first. I believe it's the only time out of 26 instances in the last 20 or 30 years in which the FDA convened a distinguished scientific advisory committee just for the purpose of telling it whether it should make a particular decision. And this is the only time the advisory committee said, yes, do this, and the FDA did not do it.
It just seems like if that's the primary concern is promiscuity among young, at least get it to everybody over the age of 18.
Right. Is this the,
Well, I'm just curious if you know if there's any sort of legislative compromises afoot. And when Lynn Wardle was here, I had the chance to sit down with him, and here was a very conservative person saying that, well, setting out his compromise. You know,
I was
abortion on demand in the first trimester.
10 weeks, he said.
Yeah,
Wasn't it 10
and-
weeks in our
10
class?
And he was
Yeah.
very, you know.
I was surprised to hear that.
He was very clear that, you know.
Now, but
not
in
everybody
our
would like it.
class, he said, not that I think I could sell it to either side.
That's what he said, that's what he told me as well, but I'm just curious to know if somebody is trying to sell that, and also
Well, he's
whether
pretty,
or not it would
he's
fly.
pretty eminent. Go ahead, excuse me.
He is, I don't know if you, if it would fly. If the writing is on the wall, which I personally hope it isn't, that Roe v. Wade could be overturned, returning us to, you know, whatever period of history there is, would that kind of compromise fly in the pro-choice? You know, is it too much to give up? I don't know.
I don't know, I certainly don't think, things are looking good for the other side. I don't think
Yeah.
they'll be compromising a lot right now. I don't know. I don't want to keep you from anything you need to do. Emily, shall we just say this is over and anyone can stay, or what? What time does it end?
I have a quick
Mhm.
question. It's in 10 minutes, or now, between now and 10 minutes now. So
Oh, okay,
whatever
all right.
works for me.
If Roe v. Wade were to be overturned, we would be back in an environment where each state has its own regulation of abortion, correct? And I know that there have been some proposals, right, to limit,
Well,
Looking-
no, excuse me, Heather, I shouldn't have said yes, because
Okay.
I'll get to why that may not be true in a minute.
Okay.
Go ahead.
I guess I'm just wondering what proposals either have been suggested or maybe suggested in terms of limiting people's access to cross state lines.
Well, that's what I was going to say. I hear a lot of people say that Professor Chemerinsky, I think in our class was one, that they would sort of somewhere between not be surprised and expect to see Congress enact something that criminalize, or individual states say that you can't cross, it's a crime to cross state lines to procure, with the intention of procuring an abortion. Nobody knows whether that would be found to be constitutional or not.
It's interesting, there was a case in New York. New York used to have, it was the only state, I believe, that had legalized abortion before Roe versus Wade, or one of the only states.
Yes, California and, actually there were 4, but an awful lot of abortions were done in New York by women from all over the United States coming to New York before Roe.
They had an abortion referral service that was run by a for-profit organization, and the court, I guess it was the New York Court of Appeals, determined that the service was illegal because it was a corporation practicing medicine instead of a doctor, even though it was just like a referral service essentially for women from out of state to find abortion doctors. So, I mean, there are ways that states can limit the access, and we just went over this in class last week, so I was like, oh, that's really interesting. Anyway, put them there.
I just have a quick question. One of the things that I'm most troubled with right now is pharmacist refusal and legislatures protecting pharmacists who refuse to fill
Right.
prescriptions for regular contraception or emergency contraception. Has there been any movement the other way? Are any states enforcing?
Yes, gosh, I wish, I can't remember numbers more than half an hour. But yes, I think there are 8 states that have taken a variety of actions to require pharmacists in their state. Massachusetts, the Board of Pharmacy was the latest one, I believe, said we're going to discipline a pharmacist who does not. And some of those have, those are of a variety of sorts. Some of them, is it Indiana or Illinois? It's one of those ones in the middle where the governor has made an executive order and saying, and then, so some of the statutes give individual pharmacists an out if they can, but they have to refer immediately to an appropriate one and know that the person will even be able to get it. And the little wrinkle that shocked me the most in these statutes was the one that attempts to deal with something that's actually happened a couple of times, where a pharmacist takes the woman's prescription, says, I'm not prescribing this, and won't give her back her prescription. One of them tore it up in front of her.
Actually, I have one more question. I apologize if anyone else.
I have a weird question. I was kind of waiting till the end, but
Go for it.
if yours is more, mine's somewhat serious. But have you read the Thanatos syndrome before?
No, never
Has
heard of
anybody
it.
in here read it? No, it's a Walker Percy. I don't know if you've.
I like Walker Percy, but I haven't read him in
This is
decades.
weird, so I'm not, and this is asking you to kind of predict the future, but I think it's an interesting question. In there, he proposed a future society where there's a new Supreme Court decision called Doe versus Dade. And basically, it says that science has proven that an infant is not a person until they're 12 months old, outside of the womb. And so this decision then legalizes, they call it peg
Infanticide.
euthanasia. And I was wondering if you could explain how Roe versus Wade could not be used to support a decision like that if science were to say that a 12-month-old infant is not a person. Does that make any sense? Like
Sort
I
of,
say,
sort of.
he doesn't go deep into the legal
Right.
arguments in the
Right.
book, but I'm basically saying that it's not a viable individual until it's 12 months old.
Well, what I would say is, first, it's not something he'd sort of made up. I was interested, I had to write a brief in a case, and that led me to sociobiologists, and they say that it's not unusual in some settings, in some cultures in the world, for birth not to be the point at which personhood is universally agreed to begin, but instead that the family sort of stands out, sort of looks at the newborn from a distance and decides whether the child is viable within the circumstances in which they live. So this is not a nutty idea Percy had, but I guess what I would say is in every part of United States culture and history, and that of nearly all of the world that we equate ourselves with, birth has always been the point at which, for some people it's the last point, you know. I mean, some people begin back here with the fertilized egg, including
Right,
many people now.
Viability has some aspect in Roe versus Wade when the fetus becomes viable, isn't that?
Yeah, that's one of the two. Either Roe says a state has the right to restrict the state's interest in human life, which has been growing throughout the pregnancy, at the point of either 24 weeks or viability, whichever comes first, becomes strong enough in the position of, from point of view of the Roe court, the Roe majority, which was 7-2, not 5-4, as we might have thought, that a state may outlaw abortion except for life and health of the mother.
Okay, so looking at what Percy says then and that, it's kind of, since it's obvious that once it's born that it can live on its own, then it doesn't really, Roe versus Wade really couldn't be, even if science.
That's what I think. I mean, I don't think
that makes
Percy
sense
is
to me
right.
too. I just wanted.
Yeah.
I have a comment on that. I don't know. I'm not a lawyer. I don't know the legal specifics, but I see Roe v. Wade as it's a woman's right to decide what happens to her body. you're looking at it from
And
the
so
child's
once the baby's
perspective.
born, it's not a
It-
part of
yeah,
the body anymore.
exactly.
Right, okay.
So I would see
Yeah,
that as
that's a good point.
completely
That's a
different
good way to put
argument.
it. Right.
My question has to do with the fact that if we are going to divide the world into pro-life and pro-choice, and there's no gray area, there's no in the middle, and that there seems to be a trend that the younger generation apparently is becoming more pro-life and less pro-choice in that division. Does that have a comment on the women's rights movement? You know, well, now we see women as having these equal rights, and we don't have to worry about reproductive rights anymore. Because if you are going to tie pregnancy to your status in society, you know, if for some reason now women have equal status, we don't need to protect them from unwanted pregnancies. And I don't know if there's any sort of that idea going on.
Well, first, in our class, I would say the majority, hard to say exactly, of your colleagues that happen to be in this seminar's position is the middle one of not, I consider myself pro-life, but I don't feel empowered or authorized to make decisions for other people. So whatever we might get to, I don't think we're there yet, if these 15 are a sample. I think you're right. And I'm going to be thinking about this tonight because I've been asked to be on a radio program tomorrow where whose producers want to talk about, and we're still looking for the second person. As we speak, they're out there combing the streets for the second person. They're just going to, they want two people who were 70s feminists, and they want one of them to have changed her mind on abortion access in some significant ways since then. So I'm going to be thinking about, and they want to know what was different about the way this issue looked in 1970 and in 2006. But I think that what you suggested is part of it. Oh, now it is after, it is 12:12, so I guess we better stop, but I would be delighted to talk to anybody who has anything else to say, tell me, or ask me. Thank you.
No connection whatsoever, and it was an absolutely great experience, and I'm so glad that they did it. Met some great people, and you know, so don't just say, I mean, the experience itself is worth it, and what better time than to get paid, to have a great experience, to make more family, and to spend a year in a really fun, interesting place that you never would have considered otherwise.
Yeah, absolutely. And I think what I was saying earlier is definitely, if you know that you do not want to be in Sioux Falls, don't apply to Sioux Falls. But be open, and yeah, certainly cast your net broadly.
We have time for one more question, I think, Professor Beal.
I was hoping you might just say something about the state clerkships, because that really hasn't come out, and you're the best representative of that.
Right.
Here.
I clerked for the State Court of Appeals here in North Carolina. I worked for Patricia Timmons-Goodson, who is now on the state Supreme Court. And my experiences were very similar to the experiences that you've heard about today. One of the major differences, of course, is that there were fewer clerks. My judge had two. In our court, all of the associate judges had 2 clerks. The chief judge had 3. But we went through very similar processes of assigning cases to each other, working with our judges. You know, if by chance one of us didn't agree, one of the clerks didn't agree with the judge's opinion, she was very open to hear what we had to say about a particular point of law, which was a great experience. I found it to be a great experience to have just after graduating law school. You're going to hear that many times. But it's really the best opportunity, I feel like, to apply some of the things that you learn, some of the practical things that you learn as a law student. It was a great experience. Are there any other questions? Well, thank you very much to our panel. I'm sure that they wouldn't mind sticking around if you all have questions for them individually afterwards. But
Just
thank you
send us an
very
email.
much.
Yeah.
Right,
There's an email.
email.